Well, good evening, everyone, and welcome. I'd like to begin by acknowledging the traditional custodians on whose lands the Australian National University sits and from whose lands I'm speaking to you today, the Ngunnawal and Ngambri peoples, as well as the traditional custodians of the lands on which each of you are living, working and learning. I'm grateful to the First Nations people of Australia who've had an intimate relationship with this landscape and the sea country surrounding it for thousands of years. And as we talk about the modern law of the sea this evening, I'd like to pay my respects to the elders of this country, past and present, and to the culture, knowledge, kinship and connection that they hold in relation to oceans and the marine environment, and extend that respect to any Aboriginal and Torres Strait Islander people joining us today. So tonight we reach the last in a continuing program of webinars that the ANU College of Law Centre for International and Public Law has been running throughout 2022 in conjunction with the Australian and New Zealand Society of International Law, or ANZL. I'm Camille Goodman. I'm a senior lecturer at the Australian National Centre for Ocean Resources and Security at the University of Wollongong. But tonight I'm here as the ANZL co-chair of this series alongside the ANU co-chair, Professor Donald Rothwell. As you're all probably painfully aware, 2022 is the year in which we reach the 40th anniversary of the adoption of the 1982 United Nations Convention on the Law of the Sea, which will mark on the 10th of December. And CIPL and ANZL felt this was a great opportunity to hold a series of webinars over the course of the year with two aims. First, we've sought to reflect on the negotiation of UNCLOS and celebrate its achievements through this series, featuring senior scholars and practitioners from Australia and New Zealand who have shared their perspectives and insights on various aspects of the negotiation and implementation of the convention. And then second, as we move toward the 10th of December and the actual anniversary of UNCLOS, we'll hold an event looking forward beyond 2022, which considers the future of the LOSC and asks whether it's still fit for purpose and what new or different challenges might arise in future. And that will feature work from the next generation of Law of the Sea scholars, the junior and early career scholars, which includes me. In February, we focused on Australia and New Zealand perspectives on the convention. In April, we had a wonderful discussion from a Pacific perspective. In July, we had a great keynote from Ambassador Tommy Coe. And in August, we discussed the institutions and implementing agreements of UNCLOS. So tonight in our final webinar, we're going to consider another of the unique achievements of UNCLOS, its Part 15 dispute settlement system. And we have four wonderful speakers joining us with great experience in that system: Bill Campbell, Judith Levine, Kate Parlett, and Professor Don McRae. And you can find more details about their life and work in Law of the Sea in the bios, which Charlene has linked in the chat. So to take us through our discussion, I'm going to hand over to my colleague, Professor Donald Rothwell of the ANU College of Law.
Thanks, Camille, and good evening, good afternoon, everyone. I'm pleased to say that I'm coming to you from USO in South Korea today, where I've been engaged in the presentation of the USO Academy of the Law of the Sea. So as Camille has indicated, we have four speakers this evening. Don McRae, who's based in Ottawa, is in a radically different time zone to everyone else. So what we've done in the case of Don is that we've pre-recorded a Zoom interview with him, and we'll come to Don McRae's presentation a little later in the session. And so the idea was that I would commence with each one of our panelists, ask them a series of questions, and then we'd move sequentially around to the various speakers and presenters. All right, Bill, thanks for joining us this evening. So we were going to start off with a general opening question. Given your experience as a senior Australian government international legal advisor, can you just commence by outlining the position that the Australian government has generally taken with respect to Part 15 of the Law of the Sea Convention?
Thanks, Don. While I can outline the position of past Australian governments, I won't purport to represent the views of the current government. That said, I note that the current Attorney General, Mark Dreyfus, in his Seabrook Chambers lecture on 13 October said that and I quote, "A fundamental pillar of the international rule of law is a robust system for the peaceful resolution of international disputes." And the attorney himself is no stranger to international dispute resolution, having appeared before the ICJ in the whaling case. I'd say successive Australian governments have been supportive of Article 15 dispute settlement, and that's certainly if involvement's been anything to go by. Australia was also an original party to the convention, though it did by declaration in 2002 accept maritime delimitation and historic bays from Part 15 dispute settlement. But by the same declaration, it accepted the ICJ and ITLOS as its preferred dispute settlement bodies under Part 15. Now, in terms of involvement, as people probably know, Australia and New Zealand commenced the very first Annex 7 arbitration and the associated application to ITLOS for provisional measures in the SBT cases in 1999. The then Attorney General, Darryl Williams, appeared before ITLOS in that case, and that was a concrete show of early government support for dispute settlement under Part 15. And Australia was a respondent in the Volga vessel release case in 2002, and in the first Article 298 Annex 5 compulsory conciliation brought by Timor-Leste in 2016. And it also made submissions in the two ITLOS advisory opinion cases. Now, it might be suggested Australia's support for dispute settlement under Part 15 is called into question by its attempted exclusion of boundary disputes from such settlement and its challenge to the competence, that is the jurisdiction of the Conciliation Commission in the Timor Sea conciliation. Just let me make a couple of observations. The first is that Australia fully participates in the process once the case is started against it, in contrast to certain other countries. And secondly, challenges to admissibility and jurisdiction are routine in dispute settlement and not indicative of a lack of support for the process. And thirdly, I'd make the point that Article 298 expressly allows for states to accept maritime boundaries from Part 15 dispute settlement, though that can still lead to compulsory conciliation, as it did in our case with Timor-Leste. And I'd say another indication of Australia's support for Part 15 is that its nomination of conciliators and arbitrators to the panels maintained under Article 2 of Annexes 5 and 7 of the Convention. And an Australian member of the arbitration panel, Henry Burmester, was appointed an arbitrator in the Annex 7 Arctic Sunrise arbitration, and also Rosalie Balkan, who was a nominated conciliator, was on the Conciliation Commission. Thanks.
Thanks, Bill. That's really helpful, and you've outlined the fact that rather uniquely Australia does have this quite extensive breadth of experience across these various Part 15 procedures for dispute settlement. Just thinking about the process associated with those mechanisms, what are your reflections on those various processes for law of the sea dispute settlement generally?
Well, I can make comments on the various processes and comparisons. Look, ITLOS, similar to the ICJ, moves very quickly in provisional measures cases and also in vessel release cases. And we've had experience of both, with the outcome in the SBT provisional measures case being more positive than the outcome in the Volga case. But irrespective of those outcomes, I think the ability of ITLOS to deal with such matters quickly is a plus. Others may differ on this, but to me, another ITLOS positive, and it's shared with the ICJ, is that I think it's logistically easier to run a case before ITLOS than before an Annex 7 arbitration. And that's because ITLOS is a standing tribunal whose expenses are borne by the state parties to the 1982 Convention and the Seabed Authority, and it has standing rules of procedure. But if you contrast that with Annex 7 arbitration and Annex 5 conciliation, where the parties need to go through a process of forming the tribunal or commission, agreeing upon or amending rules of procedure, and paying for the costs of the members of the tribunal or commission and the secretariat. Now, I'm not sure whether this is the reason why Mauritius and Maldives agreed to utilise a chamber of ITLOS consisting of 7 nominated judges of ITLOS and 2 judges ad hoc to resolve their maritime delimitation dispute. Another thing I think we'd say we've learned is the identification of potential arbitrators and conciliators through a meticulous process of due diligence is absolutely essential. And I think it would be fair to say that Australia and New Zealand didn't place sufficient importance on that aspect in choosing the tribunal in the SBT Annex 7 arbitration. It's an important point of difference between ITLOS and Annex 7 arbitrations that an Annex 5 conciliation commission does not make binding decisions, but rather presents a report which the parties then use to negotiate an agreement. Now, I wasn't involved in the very later stages of the Timor-Leste Australia conciliation, but it would be fair to say that the less formal process of conciliation, and that was insisted upon by Peter Taxo Jensen, the chair, that it helped settle an agreed maritime boundary and associated matters. And the commission of which Don McRae was a member also drove the conciliation at quite an intensive pace. And again, I think that was a good thing. And another positive aspect is that the recommendations that were made by the commission in the course of the proceedings, recommendations were made aimed at lowering tensions between the parties, including recommending termination of the treaty on certain maritime arrangements in the Timor Sea, which in turn led to the cessation of 2 other existing arbitrations between the 2 parties. In short, the Commission took a holistic view of its role in settling long-standing disputes between the parties. Just one other point. I realise that decisions are only binding on the parties, but I have had some concerns about some aspects of 1982 Convention interpretation by Annex 7 tribunals. In the SBT case, the tribunal, except for Sir Kenneth Keith in dissent, in my view, misapplied the jurisdictional provisions of the 1982 Convention. And that was later recognised in the Annex 7 by the Annex 7 Arbitral Tribunal in the South China Sea arbitration, which unfortunately, again in my view, then proceeded to make its own misinterpretation of Article 121 of the Convention relating to islands. And unlike the ICJ and UNCLOS, there is no entitlement of other states to intervene in Annex 7 arbitrations when a question concerning the interpretation of the 1982 Convention arises. Thanks.
Thanks, Bill. And some of those comments set the scene for observations that Don McRae will make about the Timor Sea conciliation. So that's really useful in terms of thinking about the formal mechanisms for dispute settlement, but Australia uniquely has also been involved in advisory proceedings before ITLOS in the 2015 request for an advisory opinion submitted by the Sub-Regional Fisheries Commission. Given your reflections that you've already said about the formal mechanisms for dispute settlement, what are your views then on the advisory processes under Part 15?
Well, my basic view is that the tribunal should keep to its correct advisory jurisdiction. My view is that contrary to the submissions made by a number of countries, including Australia, albeit we're in a minority, the tribunal found that it had jurisdiction to give an advisory jurisdiction on that fisheries matter. And to me, it's quite clear, both under the text of the 1982 Convention and its travaux preparatoires, that the advisory jurisdiction of the tribunal is limited to its seabed disputes chamber on matters concerning activities within the scope of the International Seabed Authority. And that seabed disputes chamber actually dealt with a request for an advisory opinion earlier on, and Australia made submissions in that case. But what the Cook Tribunal did was it quite, in my view, inappropriately accorded itself a more general advisory jurisdiction by adopting Article 138 of its Rules of Procedure, which was beyond its rulemaking power. And it exercised that jurisdiction in the Sub-Regional Fisheries Commission case you mentioned. Now, Australia was part of an unusual alliance of states, including the US, UK, China, Ireland, Spain, Argentina, and Thailand, all in alphabetical order, that submitted the tribunal did not have a general advisory jurisdiction. And while the tribunal's confirmation that it did have such jurisdiction really came as no surprise, it was a bit surprising that it was a unanimous decision on that point of all 21 judges. But on the other hand, a laudable aspect of the case was the range of states and organisations who actually made submissions. And this included Australia, the Federated States of Micronesia, New Zealand, Thailand, China, and the Forum Fisheries Agency from our own region, and the UN, the IUCN, the FAO, and the World Wildlife Fund also made submissions. And that was entirely appropriate, given that the request was dealing with the obligations of flag states in relation to IUU fishing and the obligations of coastal states in ensuring the sustainable management of shared stocks.
Thanks, Bill. And that's been really useful in terms of getting a sense of the breadth and depth of Australia's engagement with those various processes. And I just wanted to conclude by asking you about Article 298, which you've briefly mentioned. These Article 298 optional exceptions have become increasingly important in Part 15 dispute settlement. Can you say something about Australia's position with respect to its Article 298 declaration?
Sure. Maybe just to clarify that there are three optional exceptions. One relates to maritime delimitation, another to disputes concerning military activities, and a third to disputes in respect of which the Security Council is exercising its functions. And a state can make a declaration at any time in relation to those exceptions. Australia obviously confined its declaration of 2002 to accepting maritime delimitation from dispute settlement under Part 15. And at the time, as people probably know, Australia was negotiating or about to negotiate maritime boundaries with Timor-Leste and New Zealand. And it would be fair to say that neither country reacted very well to Australia's declaration. But I just want to give a bit of context. Australia is not alone in making such a declaration. Other countries excluding maritime delimitation include Canada, Denmark, France, Italy, Kenya, Malaysia, Mexico, Norway, Palau, Portugal, South Korea, Singapore, Spain, and Thailand. And secondly, it's apparent from the list of countries I just mentioned that some have been involved in third-party dispute settlement over boundaries, for example, by express referral to a dispute settlement body or through the ICJ optional clause. And third, Australia, under successive governments, has held the position that maritime boundaries are best settled by negotiation rather than through third-party dispute settlement. Whether that remains the case under the current government, I don't know, but the fact remains that the 298 declaration and the related ICJ optional clause declaration is still in place. Finally, one wonders whether that optional exception concerning maritime boundaries is a little illusory, given what happened in the case of the dispute settlement between Australia and Timor-Leste over their maritime boundaries. That is, it ended up, in any case, in compulsory conciliation pursuant to Article 298(1)(a) of the Convention. And had no agreement been reached as a result of the conciliation, which it was reached, the next step would have been very interesting, because as you know, Article 298(1)(a)(2) in somewhat internally contradictory terms provides that, quote, if these negotiations based on a conciliation report do not result in an agreement, the parties shall, by mutual consent, submit the question to one of the procedures provided for in Section 2, unless the parties otherwise agree. And the procedures in Schedule 2 are, of course, IPLOS, ICJ, Annex 7 and Annex 8 arbitral tribunals. Now, all that seems a bit circular, but thankfully we didn't reach that point.
Thanks, Bill. Those are really interesting observations and insights. We're going to move away from an Australian focus now and step into the world of arbitration, and particularly to think about ultimately the role that the Permanent Court of Arbitration has played in these processes. So, Judith, thanks for joining us. So, Judith, a feature of the Law of the Sea Convention is the prominence that it gives to arbitration as a means of dispute settlement. On the basis of your experience, how do you assess the merits of Annex 7 arbitration mechanisms under the Convention?
Thanks, Don, and thanks for inviting me to join in this anniversary series in the company of such experts. I'm joining you from Gadigal land, and I should say that while I was senior counsel at the Permanent Court of Arbitration, I left 3 years ago to practice as an arbitrator. And so while I think my experience at the PCA is why I was invited to speak, I obviously don't speak on behalf of the organisation, but in my personal capacity. While I was at the PCA, I served as registrar in the South China Sea arbitration, the Atlanto-Scandian herring arbitration, as well as dozens of other international disputes. As you know, Part 15 was a heavily negotiated part before consensus was finally achieved. And reflecting on the history of that, I would say if the UNCLOS treaty negotiators gave prominence to anything, it was to the resolution of disputes itself, irrespective of format, rather than trying to push a particular form of dispute settlement on parties. And that's partly why it's been so successful. It offers a flexible menu of potential procedures, which in some way mirrors the approach taken back in the 1899 and 1907 Hague Conventions, insofar as they focused on offering different approaches to dispute resolution rather than telling states how to resolve their disputes. So Part 15 starts with a choice of procedure, which, as Bill said, states are free to make declarations choosing either ITLOS, ICJ, Annex 7 arbitration or special arbitration under Annex 8. So when you refer to the prominence of arbitration, that comes about as a result of the fact that arbitration is there as a default mechanism if states haven't made a choice or if they've made different choices. Now, a default is necessary to make sure compulsory dispute settlement can proceed at all, and that there's no procedural stalemate from the get-go. As for why arbitration is the default mechanism, that's both a result of the historic effect of France's influence during the treaty negotiations, but it's also a logical result of the nature of arbitration. So I won't get into the historical aspect, but I can talk to features of arbitration that might make it appealing as the default mechanism. The prime reason, it seems to me, is confidence in the decision makers. And in arbitration, parties get the chance to shape the identity of the decision makers. They know they can each pick one arbitrator and they get a chance to agree with the other side on the other three members. So if you're going to force states to accept a form of compulsory dispute settlement, it's logical to force them to the form where they can't, at least to begin with, lack confidence in the decision maker. And it was really interesting to hear Bill's comments, sort of remorse in not doing proper due diligence in appointments for the SBT case, and then later his pride in the fact that designations of really qualified Australian candidates to the UN panels has led to their participation in arbitrations and conciliations. So having a choice in the decision maker is an appealing aspect of arbitration. And secondly, the parties get to shape the procedure, which in arbitration is as flexible and can be tailored to suit the particular needs of the dispute. That may relate to the length, the speed, the format, bifurcation, the language it's conducted in, the hearing locations, the use of site visits, technical input, a whole slew of possibilities. And this is borne out also in the numbers, according to a recent chapter by my former colleague, Garth Schofield, in the Cambridge Companion to Arbitration. 37 states have expressed a preference for ITLOS, 21 for the ICJ, and the remaining 127 parties have either expressed a preference for arbitration or made no declaration such that they're deemed to have accepted arbitration pursuant to Annex 7. And we've seen that the majority of disputes referred to compulsory settlement under the Convention have been initiated as Annex 7 arbitrations.
Thanks, Judith, for that. And I guess to build upon some observations that Bill made, an interesting aspect of Part 15 is this interaction between ITLOS and Annex 7 tribunals, which for Australia certainly raised some interesting issues with respect to jurisdiction in the Southern Bluefin tuna case. Can I just ask you to reflect from an institutional perspective, what are the challenges that throws up at a practical level?
So as you say, there are a few parts in Part 15 that reference both ITLOS and Annex 7 or deal with the interaction between them both. We've already discussed the choice of procedure, so that if one party has chosen ITLOS and the other Annex 7, the default will be Annex 7. Two other interactions bear mentioning, I think. One is on provisional measures in Article 290, and the other is on the appointment of arbitrators in Article 3 of Annex 7. So under Article 290, if the court or tribunal is already constituted and considers that prima facie it has jurisdiction under the part of the Convention, then they may prescribe provisional measures considered appropriate in the circumstances. But if a state seeks provisional measures before an Annex 7 tribunal has been constituted, then under Article 295, pending the constitution of that tribunal, the parties can agree on another body to decide interim measures, but if they don't, then they go to ITLOS, which may prescribe or modify or revoke provisional measures in accordance with the article, if it considers that prima facie the tribunal which is to be constituted would have jurisdiction and the usual other requirements of urgency are met. So there have been a number of cases in which states have resorted to ITLOS for provisional measures pending the constitution of an Annex 7 tribunal. Bill mentioned Southern Bluefin tuna. There's also the MOX plant, Argentina, Ghana, the Arctic Sunrise case. And you mentioned challenges that came up in Southern Bluefin tuna, perhaps the difference in approach between ITLOS and the arbitral tribunal on jurisdiction. In response to that, I'd just recall the differences there were between a prima facie review of jurisdictional issue at the interim measures phase versus the jurisdictional review itself, which apply different standards. And in any event, as Bill observed, that conflict was resolved in observations by the South China Sea Tribunal, at least, which favoured the approach of ITLOS and of the dissent of Kenneth Keyes. But that same issue could happen if you even have only one body taking both decisions, applying the two different standards. And Part 15 jurisdictional provisions are quite complex, not so clearly worded, can lead to a difference of views. But a number of cases since Southern Bluefin tuna have gone a long way to clarifying those provisions, and reading over that jurisdiction would reduce the uncertainty. The other interaction that I'd want to mention is that the role under Annex 7 in appointment of arbitrators. So when if a state fails to appoint an arbitrator, or if the two states can't agree on the other three arbitrators, it falls on the president of ITLOS to make appointments. And under the convention, the preference is to choose names from the list maintained by the Secretary General of the UN. And many of the people who've served as arbitrators on Annex 7 tribunals have also been judges of ITLOS, and that may be by virtue of them being on the UN list, being known to the president who's appointing them, It doesn't hurt. It may contribute to a consistent jurisprudence. I don't think it causes any practical challenges institutionally for the PCA. It may cause some challenges in other regards, including the diversity of the list, especially if member states don't keep their nominations up to date. And I remember with some frustration looking through that list and seeing some states hadn't made appointments at all. Some states still had people on the list who had passed away. And while the PCA is involved in appointing arbitrators all the time, has done so involved in over 500 appointments, might occasionally take a different approach to appointments, but practically speaking, these haven't really involved challenges from an institutional perspective. The PCA deals all the time with cases that are bifurcated as between jurisdiction and merits, and also sometimes has cases where provisional measures might have been ordered by a domestic court before a case comes to it. And usually the parties are capable of providing relevant documentation from other fora, spelling out the issues, and the tribunals are capable of addressing them. Indeed, even if the party is not formally participating in making the jurisdictional arguments, as what happened in South China Sea and Arctic Sunrise.
So Judith, as you know, the Permanent Court of Arbitration is not directly referred to in the Law of the Sea Convention, and yet it's become particularly associated with Annex 7 arbitration. Can you just give us a bit of institutional history, I guess, as to how that relationship has come about and the role that the PCA plays in that process?
Sure. So the PCA was established many decades before the convention by the 1899 Hague Peace Treaties to be accessible at all times for immediate recourse to help resolve international differences, including to support special tribunals. It has served as registry, providing administrative support in 15 cases under the UN Convention on the Law of the Sea, all in the last 20 years. 14 of these are Annex 7 arbitrations, and one was the conciliation that Bill mentioned. And they really include a range of issues. Maritime delimitations, amongst the early ones were Barbados, Trinidad, and Guyana, Suriname, and more recently Bangladesh, India, as well as cases relating to vessels like Arctic Sunrise, the Dovegate Integrity, fisheries-related cases, those relating to the marine environment, and other varied types of maritime claims. And the PCA has also been registry in non-convention cases dealing with the law of the sea issues, such as Eritrea, Yemen, Croatia, Slovenia, as well as fishery treaty review bodies. But as you say, Don, where is the PCA in the treaty, and why and how have those cases come to the PCA? Annex 7 is silent on case administration, but it does provide in Article 5 that unless the parties otherwise agree, the arbitral tribunal shall determine its own procedure, assuring to each party an opportunity to be heard and to present its case. And in that discretion to determine its own procedure, tribunals in consultations with parties have preferred to have an institution involved as registry rather than run the proceedings in ad hoc in a kind of administrative vacuum. Some of the reasons for that is they want a neutral channel of communications between the parties and the tribunal, which can, in the old days, you print out note verbal and give them to a bicycle courier in The Hague to take to the embassy, but it's also applicable for handling emails. Maintaining an archive of correspondence and pleadings and evidence, organising hearings all over the world, not just in the Peace Palace, but there have been Law of the Sea hearings in Istanbul, Vienna, Singapore, Dubai. Also managing the deposit and fees and costs, which, as Bill said, don't come from the PCA's budget, but are contributed by the participating parties. If they use the PCA and it's a developing member state of the PCA, they might have access to the PCA's Financial Assistance Fund, which Sao Tome and Principe used in the Dovegate Integrity case. And they might also benefit from privileges and immunities under the headquarters agreement with the Netherlands or host country agreements elsewhere. And the effect of all of that is to streamline the proceedings and ultimately reduce costs by lightening the tribunal's administrative load. Some of the logistics involved in these cases are quite large and heavy on the administrative front. That includes helping find and contact experts, marine biologists, maritime safety experts, damages experts. One of the early cases, Guyana Suriname, involved a site visit of the independent expert to help locate a boundary marker that, is quite difficult for 5 international lawyers on their own to organise without the assistance of a registry. Likewise, the Bangladesh-India visit to the Bay of Bengal. Interestingly, Bill mentioned non-parties who might be interested in the proceedings. We saw that occasionally comes up as well, and the diplomats or representatives from governments of other states, member states of the UNCLOS Convention, might want to liaise with the PCA about the status of the case, as happened with Malaysia, Vietnam, and several other observer states in the South China Sea case. Very briefly, in terms of the mechanics of how the PCA becomes a registry, usually at the very beginning, after being appointed by the parties or the president of UNCLOS, the presiding arbitrator or all 5 members will contact the PCA Secretary General to see if the PCA would be willing to act as registry. Sometimes that initial contact comes from the state's parties themselves, and the tribunal, otherwise the tribunal will seek the views of the parties. The agreement and the arrangement is then formalised in terms of appointment at a first procedural meeting. Several of those are available on the PCA website, and the PCA Secretary General will designate a legal counsel on the staff to serve as the registrar who assists in the tribunal throughout the course of the case.
Thanks, Judith. That's really helpful in terms of understanding some of those practical issues. Just in view of the time, if I can just ask for a short response to the fact that the PCA seems to have become inexorably linked to the South China Sea arbitration, with many scholars, commentators, and I regret to say my students constantly referring in error to the PCA as being the arbitral body in that case. What's the internal sense from the PCA that you can reflect upon in terms of that close connection between the PCA and the South China Sea arbitration?
I think in the reporting and commentating, concision is desirable, but not at the expense of precision. And it can admittedly be a mouthful to say an arbitral tribunal constituted pursuant to Annex 7 of the UN Convention of the Law of the Sea, receiving registry support from the PCA in The Hague. Law students with word limits or journalists with general audiences will want to shorten that. And PCA decided XYZ is not the correct way to shorten it. Other short forms are more accurate, defining it as the tribunal, an UNCLOS tribunal, the South China Sea Tribunal. I don't think it's the most serious issue arising from the South China Sea case. The PCA in its press releases is cautious to describe the tribunal correctly. I know the Sydney Morning Herald, sometimes really gets it wrong, referred to it as a judgment by the Permanent Court of Arbitration, but it seems to have improved. When I last checked, it referred to it as an international ruling in The Hague. And interestingly, Wikipedia gets it spot on, calling, I don't know if you wrote that, Donald, or somebody with knowledge has the correct description there. But in our experience at the PCA, those most active, the users, the states who have used the PCA as registry, the tribunal members who rely on the PCA for administrative support, they're able to make a clear distinction between the PCA as an international organisation and the services it offers from the tribunals who make those decisions.
Thanks, Judith. You've just set me with a goal to come up with an appropriate acronym for my students. Let me now turn to Kate. And Kate, thank you for joining us from the United Kingdom. You haven't had a new Prime Minister installed overnight, have you, while you woke up this morning?
I think the UK is struggling to catch up with Australia for the number of Prime Ministers in a year.
Okay. So, Kate, thanks so much for joining us. And we really look forward to your views as a practitioner on these matters. So, as a practitioner at the International Bar, how are the Part 15 Law of the Sea Convention dispute settlement mechanisms viewed by your state clients?
Thanks, Don, and thank you to both you and Camille for having me. It's a real pleasure to participate in this panel, even early in the morning here in Edinburgh. I mean, I think generally speaking, I would say that all of the Part 15 dispute settlement mechanisms that have been used, that's Annex 7, ICJ and ITLOS, are viewed pretty positively by state clients, and they obviously have their slight nuances and some advantages, but often, of course, one doesn't really have a choice. So, you know, you sort of end up with going through the menu of options that Judith mentioned. You do end up sort of with one or two possibilities. And I think, you know, a lot of times the situation is such that the state is just quite happy to be in a situation where there is a tribunal with jurisdiction, whichever of the options that may be. Of course, we mentioned earlier that we have Annex 8 arbitration as well, but of course there haven't been any Annex 8 tribunals. And I think also we mentioned, or Bill mentioned, the Annex 5 conciliation process. I think with that, in terms of how that's viewed by state, it's probably a little bit early to say, although Bill's spoken to the process that was conducted between Timor-Leste and Australia. And I think from the outside, and this was, I think, consistent with what he said, it looks like the outcome was positive there overall, in the sense that an agreement was reached. It would have, of course, been quite interesting to see, as Bill mentioned, what would have happened if an agreement had not been reached, because of what the convention says about that, which seems to me to be quite unclear. So we have Annex 7 arbitration, which is, of course, the most frequently used, and that is really largely a product of the fact that it's the default procedure. Judith mentioned that. I think one of the very interesting shifts that we've seen in recent cases has been towards the use of ITLOS chambers rather than Annex 7. That was something also that Bill mentioned. So we're seeing a situation where states agree after a dispute has arisen that they will actually refer it to an ITLOS chamber rather than going down the Annex 7 route. And I think from my understanding is that the most significant factor there is cost. Bill mentioned that might be the factor in the recent Mauritius-Maldives arbitration. It was also a significant factor in the Ghana-Cote d'Ivoire proceedings. So, of course, parties pay for Annex 7 tribunals, and they can be quite expensive, but they don't pay for ITLOS or ICJ chambers. We haven't seen the same appetite for referral to ICJ chambers. That's, of course, also an option, but it will be interesting to see if that is picked up on in future cases. So I think generally, I mean, I would say all of the procedures are viewed quite positively. For states, the choices are limited, but we are seeing that states are taking more control over that choice by looking to see whether they can agree post-dispute that they switch to another mechanism. And that's quite an interesting recent development, I think.
So, Kate, you've already touched on this a little bit, but I'm wondering if I can draw you out a little bit more about some of the critical aspects that you would draw attention to clients with respect to the differences between ITLOS and Annex 7 arbitration.
I mean, Don, it's a really interesting question. And I think, of course, when you're advising a client about these things, you would list the pros and cons. All, of course, really depends on the particular dispute. So it largely depends on the subject matter of the dispute. And one would look to see, for example, with ITLOS, if there is jurisprudence that would guide the tribunal that they're likely to follow in future cases, et cetera, et cetera. I mean, I think specifically with Annex 7 arbitration, one of the significant downsides that I've already mentioned is cost. One of the positives on the other side, as Judith mentioned, is that the procedure is more open than if you go to a standing tribunal. So if there is some way of conducting the proceedings that the parties particularly want to happen, you have more flexibility in Annex 7 arbitration than you would before ITLOS or the ICJ. Of course, one of the difficulties is that oftentimes you can't reach agreement on that between the parties. And I think even though there is this flexibility, it's unusual, I think, to see an Annex 7 tribunal depart from the usual procedure that's conducted unless the parties agree to that procedure. So there are going to be some constraints on that flexibility, but there is that possibility there. So far as concerned ITLOS, I think one of the difficulties is that it's quite untested when it comes to substantive issues. That is changing over time as they render more decisions and they're more involved in cases, whether that's through chambers or through the whole court. But that's one of the things that I think is a possible downside or a con compared to, for example, the ICJ, where there's probably more experience in handling law of the sea disputes than before ITLOS.
So, Kate, that's a nice segue into the next question. We haven't actually spoken a great deal about the International Court of Justice in the webinar to date. So let's now get the focus on the ICJ in particular, which raises completely different jurisdictional issues. So setting aside the jurisdictional questions, what are the advantages that state clients see in having law of the sea disputes settled by the International Court of Justice?
Well, one thing I think that I've seen quite often is that states are keen to emphasize the political weight that the ICJ has with it. It's part of the UN system, and I think that sort of structural point really assists states when they are referring disputes to the court, and assist them to justify that domestically. And I think you see that quite often, or in recent times, you've seen that quite often with respect to disputes originating in South America, that really there is this emphasis on the ICJ as forming part of this system, and we adhere to the system of international law, et cetera, and that is a real positive. I think also we have seen that the ICJ has built up a pretty significant body of jurisprudence, particularly in maritime delimitation cases. There are a couple of outliers, I would say, but I think it's getting to the point now where one could say that the ICJ is generally considered to offer pretty predictable outcomes, which I think is an attraction for states. As I mentioned, there's no cost involved with the ICJ. That's a pretty significant factor for some states. And I think also that the system by which states can appoint judges ad hoc is still considered to offer some advantages. So you don't have that full flexibility that Judith was talking about choosing your tribunal, but you do have the possibility of saying to your domestic electorate, we have this person that we've appointed who we think is really good, and we think they're going to be influential, and they're going to make sure that our perspective is put forward to the court. So I think those are the things that one sees that are being relied on by states when they're referring disputes to the ICJ. Again, one is still constrained by what the options are. So often you're in a situation where one state would love to be before the ICJ, but that's just not possible because of the way that the default procedure operates under Part 15. And as I mentioned before, it's interesting to see that we're getting referral of disputes from Annex 7 arbitration to ITLOS chambers, but not to ICJ chambers. I don't know personally what's driving that. There's only 2 examples so far, I suppose, so it's a small pool of experience, but it'll be interesting to see if there is a move to use ICJ chambers in future cases as well.
The observation you make, Kate, about Latin American states especially showing enormous confidence in the court is very apt. And there's an interesting study published just a few years ago focusing particularly on Nicaragua and its experience before the International Court. And so many of the cases Nicaragua has brought have had a very strong law of the sea dimension to them. Kate, I just want to close by getting your perspective on an interesting dynamic that's begun to emerge, and that is that we've seen some prominent examples in the past decade where some state parties have refused to participate in proceedings brought under Part 15 and have not appeared before ITLOS or Part 7 arbitral tribunals. What impact, in your view, has this had on the confidence in the Part 15 proceedings that we've been talking about today?
Well, it's a very interesting question. In my view, actually, it's had a pretty small impact or very little impact. And I think this is because the tribunals have adopted significant measures to ensure that their awards and judgments are credible and have really tested the applicant's case. So I think in case of non-appearance, from my perspective, there are two essential things. One is that the parties have to be given a full opportunity to participate throughout the proceeding. It's not the case that there's a cutoff date by which one should turn up. And so the tribunal needs to reiterate to the parties that it's open to them to participate at any time. They need to have full and open communication with both parties about all steps to be taken in the proceedings. And I think what we've seen in the cases where there has been non-appearance, there's been a record in the award or judgment of how that has taken place, which has really contributed, I think, to confidence about the process. The other thing that we've seen quite often in these cases is that the tribunal has taken into account indirect or informal information that's provided by the non-appearing party. For example, there was the position paper by China in the South China Sea arbitration. There was a memorandum by Russia in the case concerning the detention of 3 Ukrainian vessels. And there are other examples of this in cases that are not in the specific context of law of the sea, but for example, before the ICJ in the Guyana-Venezuela case and the provisional measures phase in the recent case between Ukraine and Russia concerning the allegations of genocide. Of course, the court taking into account this information enables it to be in a better position to test the applicant's case. And really that's the second point that I think is essential, which is that the tribunal really has to be in a position to ask questions of the appearing party at all stages of the proceedings and invite argument on specific issues, really to ensure that it's not just endorsing the applicant's position, but it's really trying to put the other side to the applicant and making sure that its case is fully tested. There's also the possibility that it can engage its own experts. And I think where there's a non-appearing party, that can be particularly useful, where you only, especially where the parties have appointed experts or the party. So you have a party appointed expert on one side and the tribunal appointing its own experts really enables it to be in a position to test that evidence. I think where the court takes into account this information, so for example, where it appoints its own experts or where it takes into account the information that's informally provided by a party, what's really essential is that the appearing party is given a full opportunity to engage with that evidence and engage with the arguments that are made. It wouldn't be appropriate, for example, for a tribunal to accept an informal submission that comes after the close of the oral proceedings without giving the appearing party a chance to comment on the information that it intends to take into account. But I think overall, I would say that and you notice this particularly, I think, with the South China Sea arbitration, that there are specific parts of the tribunal's award that where they record what they did, and they record the questions that were put, they record the measures that they were taken, that they took, and they record the ways in which they tried to engage with the non-appearing party. And I think that all of that goes to instill confidence in the tribunal's award, despite the non-appearance of a party.
Thank you so much, Kate. Those are really excellent insights. We're just going to now turn to the pre-recorded Zoom interview I did with Don McRae, which I recorded in the last 2 weeks. I know that some of you have been sending in some questions via chat, but please continue to do so. So we'll now engage with that conversation with Don McRae, and we'll return at the end of that for some discussion time. So Don, welcome to this webinar. It's a real delight to have you joining us from Ottawa, and especially given your connections with Australia and New Zealand, it's terrific to have you involved with this event.
Thank you very much. It's a great pleasure to participate in it, and a great honor as well.
So Don, as you know, the focus of this webinar is looking at dispute settlement and dispute resolution under the law of the sea generally, but particularly with respect to the law of the sea convention. So I wonder if we could start off with a general question. There's been a lot of debate about the Part 15 mechanisms under the law of the sea convention and when they were finalised in 1982. How do you see those mechanisms having evolved over the 40 years since the convention was concluded?
Well, I think that if one had tried in 1970 to predict what would happen, one wouldn't have anticipated the volume of litigation that has actually occurred. It's been much more than I think the one would have anticipated. I don't think that the provisions were a real reflection on a commitment to dispute settlement. In fact, the variety of options that existed indicates, I think, perhaps some kind of skepticism about whether there would be dispute settlement. They couldn't obviously pick on one particular process, so they gave a variety of different processes. And I'm reminded of something that Jean-Pierre Cot wrote when he did his work on conciliation. And he said that states included conciliation in their treaties because they wanted to show they're committed to dispute settlement, knowing that they would never, ever use it. And I have a feeling that that might have been somewhat of what was happening in Part 15. Yes, we'll put it all in there, but most of us don't expect we'll ever use it. I think some of the things have been surprising. I think, for example, the prompt release litigation in UNCLOS, it demonstrated a need, but no one would have anticipated it. I think that if one had looked, I would have said that I would have expected that there would be more activity in UNCLOS and less activity in the court. Surprisingly, instead, there was a substantial amount of activity in the court, particularly in maritime boundary cases in that period. Maybe that's not going to last, I don't know, but it coincided with a general increase in the use of the international court for cases being brought by states. And so I think that there's much more happening than one might have expected. Some things obviously are not being used. I'll say a little bit conciliation, which is probably a surprise shortly. But I think that the court continued to be active, and UNCLOS and Annex 7 to some extent, surprisingly, have been surprisingly active.
Thanks, Don, for those opening remarks, and they help to set the scene for some of the matters we're going to discuss. Let's move on to discuss conciliation. You were a member of the Timor Sea Conciliation Commission. Can I just ask you to reflect a little for us on the merits as you see it of conciliation as a means of dispute settlement under the convention?
Well, I think that there is a danger in extrapolating from a single instance, and all we have is basically a single instance, because it's very, as I mentioned, it's very fact specific, very party specific, and maybe even tribunal specific. I think at the outset, I was somewhat skeptical of being able to use conciliation to draw a line. Because maritime boundary disputes, one party has one line, the other party has another line, so where's the room for conciliation? But I think that what the Commission did, and maybe this is an inherent possibility in conciliation, it broadened the range of things that can be taken into account in drawing a maritime boundary. And if we think of the law of maritime boundary delimitation, it requires relevant circumstances to be taken into account. But of course, we know, in fact, not many relevant circumstances are taken into account in the current approach to delimitation. But conciliation was all about relevant circumstances. It was all about looking at circumstances differently, looking at what the interests were of the parties, what was really at stake, how could those interests be accommodated, asking quite different questions from what a court would ask. And of course, what came through is that it really was not just about a boundary line. It was all about the resources in the boundary line. I mean, the interests were really over Greater Sunrise. And although Timor-Leste said boundary was important to complete its sovereignty, what that was code for was we want access to Greater Sunrise resources. And while Australia said we want to uphold the CMAT's agreement, they were probably much more concerned about protecting their line with Indonesia. So there were elements in there that would never come to light in a court case, and they became the way in which one could possibly resolve this if you could get an accommodation of those interests. And what the Conciliation Commission was able to do was to put together a comprehensive package. No court can put together a comprehensive package where, if you look at the detail, the location of the line to some extent, particularly in the East, reflected the particular interests that the parties had. And the line became a way to resolve that, and the resources became a mechanism to allow them to do it. Now, having said that, conciliation was probably specific to the parties. When one considers the relationship of Australia and Timor-Leste, going back to the involvement of Australia military in Timor-Leste during the Second World War and the close relations that were built up then, if you consider the fact that during the independence struggle, there was a lot of negativity about Australia seeming to support Indonesia rather than being fully on side of Timor-Leste. But at the same time, you had many people from Timor-Leste going to Australia during that period of struggle and becoming Australian citizens. And the Timor-Leste delegation was partly members who were both Australian and from Timor-Leste, but also had Australian citizenship. So I think to some extent, it was a bit of a family affair in many ways of looking at it. And I think that's a unique situation, and that obviously is not necessarily going to be found in other places. So I think if you look at it generally, what it offers for law of the sea and other kinds of areas is it's a different process for settling the disputes. A process where a third party, and this is a commission in this particular case, can enable states who have got a problem, but they can't anymore talk about it because one has a particular barrier, the other has another barrier. And the third party becomes the means by which they can communicate. We actually didn't meet with the parties. For most of the negotiation, we met with the parties separately. 9 o'clock or 10 o'clock in the morning, Timor-Leste, and 2 o'clock in the afternoon, Australia, or vice versa. Or it was important, 9 o'clock in the morning, and then 11 o'clock in the morning with the other. But they didn't get in the same room. And so they were able to talk. They were able to talk frankly. The relationship in that sense had broken down. So what you had was an ability for the parties to talk to each other through a third party, through, if you like, a facilitated negotiation, because they negotiated an agreement between them essentially, but through the medium of the commission. And that, I think, is what it offers to states in other kinds of situations.
Thanks for those insights, Don. And the issues arising from that conciliation and the outcome of the Timor Sea Treaty are still live matters on the public record here in Australia. Let's switch now from conciliation processes to the International Court of Justice, the other end of the spectrum, I guess. So you were recently a judge ad hoc in the Nicaragua-Colombia case before the International Court of Justice. And as you observed in your opening remarks, the court has had a really long-standing role in law of the sea dispute settlement. What do you see as the significance of the ICJ and its role in law of the sea dispute settlement?
Well, I think it has made an enormous contribution, but primarily in the area of maritime boundaries. I think that if you look at the history of continental shelf maritime fisheries boundary negotiation, you get North Sea cases, Tunisia, Libya, Gulf of Maine, Libya, Malta, where a lot of the issues were worked out, and the whole concept of a single maritime boundary emerged. And so it started with a very active role. Then I think since the convention, what it's done is taken the rather unhelpful provisions in Article 74 and 83, which don't really tell you very much, and provided a framework for applying those provisions in specific maritime boundary cases. What it has done is elevated equidistance, which I think since the North Sea case had been in decline. Certainly, I was involved in the Gulf of Maine case for Canada, and we argued equidistance strongly. We were quite disappointed when the court didn't uphold our position, but that was a trend that was happening. It was reasserted a little bit in Libya, Malta, but I think that the negotiations sort of rejected equidistance as the primary means of settling maritime boundaries. And that was the sense behind Article 74, 83. And of course, the court changed that. And they changed that largely through, or it was developing in many ways, largely through the Black Sea case, where it developed this three-step approach. It was a two-step approach earlier, and this became a three-step approach in Black Sea. And their Black Sea case, I think, did a very interesting job of giving a framework for parties and the courts and tribunals to approach delimitation. Now, you can criticize the way in which the court itself has applied that three-stage approach. And I've been critical of it myself. And I think that instead of having a three-step approach, they've got a merged first step and second step, when in fact relevant circumstances are taken into account in the drawing of the equidistance line, as well as taking into account later separately. And I think there's a real problem with that. And so I think you can criticize how it's been done, but the reality is they developed the framework, which will probably will be universally used. In respect of other areas, I think the contributions have been less. There have been fewer cases. If you take the fisheries jurisdiction case, the UK and Iceland, I mean, really, that decision, which obviously is still cited because there's interesting general issues in it, but basically it was bypassed by the convention. Really, the idea of 200 miles fisheries jurisdiction was in process and was developing, and the court, it's a slightly anachronistic decision, I think, in that case. And in some of the other cases, that could have had an interesting outcome if the court had taken jurisdiction. The Canada-Spain case would have been a very interesting decision if it ever got there. And I think the lack in other areas came quite clear in the Nicaragua-Colombia case, where the court, the one you mentioned that I was judge ad hoc, where the court had to deal with the contiguous zone, but there's no court jurisprudence in dealing with that. So it was really starting in first principles. So it didn't have the history of it. And when it came to straight baselines, well, there was really only, I think, Qatar Bahrain was the only other court decision. And so really you get now going right back to the Anglo-Norwegian fisheries case to try and articulate a meaning for terms developed back in the early 1950s. So I think that potentially it will continue to make a contribution. I wonder whether the things will change over time, whether the UNCLOS will become more the tribunal with Annex 7 tribunals as well. The number of judges historically with special expertise in the law of the sea has been quite large, and some particularly prominent figures in the court. I suspect, often with significant diplomatic experience, I suspect that may change over time. And I think that courts were using and have been using the ICJ because of that historical expertise, because it was the court in which those early cases were decided. And I think also the ICJ they were provided with a ready jurisdictional base through the ICJ. And of course, you can't underestimate the impact that Nicaragua has had with so many cases that they've brought and cases brought against it have been a large part of the development of the courts jurisprudence.
Don, we've covered a wide range of areas in this discussion, so I wanted to really thank you for making this contribution to the webinar this evening.
Thank you very much. It's been a great pleasure.
So we have two questions that come in, two substantive questions that have come in via chat, and I'm actually going to go to the questioners who I think are still with us, Francis and Caroline. I'll let you ask those two questions, and then I'll go to Kate, Judith and Bill in terms of answering those questions. And before I do so, I should have acknowledged the fact that Don McRae is continuing as a judge ad hoc in the International Court of Justice in the next phase of the Nicaragua-Colombia case. And just in the last few weeks, the court has issued a very interesting order in terms of the next oral phase of that particular proceeding that some of you might be interested in. Caroline, I can see that you're on screen there coming in from Auckland. Great to see you. You had some questions in the chat. I'll just let you put those orally.
Yeah, kia ora everybody, and thanks Don. Thanks very much everybody for your contributions. Greatly appreciated. The first question is on advisory opinions on climate change. And that question has got a few prongs. I'm asking whether panelists think that LOSC would agree to give an advisory opinion on climate change if the Small Island States Commission asks for one, and what you might see as the constraints or the boundaries within which LOSC would have to operate if it did get a request for an advisory opinion, which we might assume would be on ocean acidification and pollution. And in the back of my mind, I'm also wondering if the ICJ has also asked for an advisory opinion, whether there might be some element of sequencing that could be important or might make a difference in what each body is how it reasons its response to these questions, perhaps. And then I just had a little question about conciliation. I was curious to know if anybody is able to comment on the extent to which in the Timor Sea conciliation, the Commission also put suggestions, substantive suggestions into the mix, as well as helping the parties identify their interests and helping them or facilitating them with their negotiations in the way that was described in the very good video from Don just now.
Thanks, Caroline. Francis, can I go to you for your question?
Thanks so much, Don. Sure. I wanted to pick up on something which Bill had mentioned about interpretation and the interpretation and application of provisions of UNCLOS, and just wanted to ask the panelists if they had any observations on any particular, I guess, common or divergent approaches or trends as between the different dispute resolution fora, and also I guess interested in actually something which also Judge Ad hoc McRae also touched on, of course, in his dissenting opinion in Nicaragua earlier this year, but also in his remarks, whether there might be any different attitudes that we can observe in the last 40 years as to particular forms of evidence relevant to interpretation. For example, attitudes relating to state practice, for example, being possibly a more well-known contentious example. Thanks so much for all the presentations.
Thanks, Francis. So I'll go to Kate, Judith, and then Bill. If I can ask you to limit your remarks to about 3 minutes. So over to you, Kate.
Thank you. Thanks very much, Don. And I also really enjoyed the presentation by Don McRae. And it was a bit, obviously he can't comment on what's going on behind the scenes in that, with that very interesting question that's been posed in the pending case. But that's one I think everybody will be watching carefully. And I also just wanted to note as well that he has been appointed by Belize as judge ad hoc in the Belize Guatemala case, which has a maritime delimitation aspect as well. So he will be participating in that one too. I thought I might just respond quickly to France's question, because I think it's a very interesting one, and it's something that is something that I've explored. I've got a book coming out with, I mean, this is not an advertising opportunity, but I do have a book coming out next month with that's co-authored with Natalie Klein called Judging the Law of the Sea. It's coming out with OUP. And one of the things that we've looked at in that is how tribunals have interpreted and applied the UN Convention in their case law, and looking at different themes. I think one area where you can definitely see that there's been a trend where the different fora have been influenced a little bit by each other is in respect of maritime delimitation. And you see that with the emergence of the 3-step methodology for delimiting the EEZ and continental shelf. And then you see that also with the way that the jurisdiction over the extended continental shelf has developed, and particularly the shifts that you see in the ICJ's approach to that issue. And so I think you definitely see a process of cross-fertilization there. There will, of course, be other examples, but those are the ones that spring to mind. Caroline, of course, has asked a very challenging question about advisory opinions. I think I might leave it to others to respond on the substance of that. But I think in terms of the question of sequencing between ITLOS and the ICJ, you have to really look at what the bodies are going to be able to do, what their procedures require them to do. And I think for the ICJ, if they're referred a particular request, unless there's an agreement to defer that pending the resolution of another advisory opinion request, that there wouldn't necessarily be provision for any kind of sequencing. The court has, I think, made some innovations to its procedures in recent years, and you see this particularly with respect to cases where expert evidence is involved. But those are, well, I call them innovations, but they're probably a little bit at the edges of changing little things rather than taking massive steps in terms of procedure. So I think that would be a bit of a difficult one for the court to do anything particularly radical in that regard. Thanks, Don.
Thanks, Kate. Judith, your comments?
Sure. So in response to Francis and common trends between the fora, I'd note 2 procedural trends that actually stem from what Kate was discussing with non-participating parties, making tribunals have to be quite proactive in their approach to testing their evidence. And the 2 ways in which that was done in South China Sea was through appointment of independent experts, and also through the posing of questions, focusing the parties on issues in dispute. And at the 70th anniversary of the ICJ seminar, some of the court's users and judges commented that this would be a good thing for the court to do. So it's been really interesting to see, for example, in the armed activities Uganda-Congo case, that the court used an independent expert to assess damages. And also in that order that you just mentioned, Donald, from Nicaragua, Colombia, the court proactively getting parties to focus on particular issues of interest. Very quickly, in response to Marcus Humphrey's comment about the successful conciliation of the Timor Sea boundary, he mentioned the benefit of providing certainty to private economic interests. And that's an interesting point when reflecting on some of the comments about costs of arbitrators in tribunals. Those costs are nothing compared to what's at stake in these disputes, whether that's for, fisheries or oil and gas reserves. So in context, the costs are quite small. Secondly, the costs of arbitrators are also quite small in comparison to the cost of lawyers who charge irrespective of the fora. And for that, I'd refer the audience to some remarks of Philippe Sands on the centenary of the 1907 Hague Convention, talking about costs overall when looking at the calendar. And if you can get a procedure that's quick and efficient, even if you're paying for it, it may end up being cheaper. And finally, Caroline, on conciliation and climate change advisory opinions, I don't have any particular insights. I've heard there may be one in the works. I know in South China Sea, there was a lot of consideration of the web of environmental treaties in connection with the Part 12 claim and how to interpret UNCLOS in that respect. And just as a final taster, the Paris Agreement has compulsory conciliation provision that hasn't had any attention at all. And maybe those small island states could think about whether the Timor-Leste Australia Conciliation Commission poses an interesting example that they could follow in other treaty contexts. Thanks.
Thanks so much, Judith. Over to you, Bill.
Look, just in relation to advisory opinions on climate change, I think it would be a shame if advisory opinions were sought both from ITLOS and an advisory opinion from the ICJ. I think it'd be far preferable for an advisory opinion, if one is to be sought, simply to be sought from the ICJ, because it could be more comprehensive. As to seeking an advisory opinion from ITLOS, it would have to be related to the Law of the Sea Convention. But on the other hand, if a request went to ITLOS, there's no way I can see ITLOS refusing the request, if I can put it that way, because I don't think it would be inclined to. But even under its, I think it was Article 138, which created this sort of more general advisory opinion, you'd have to find an organisation of states that would request the opinion. In relation to conciliation, I think there was a question about whether the Commission actually put substantive proposals or to the parties in the course of the conciliation, and I think the answer to that question is yes, they did. Make certain, put suggestions to the parties about what might lead to a solution. If I can just mention the question of cost, which Judith mentioned, it's true that the costs of a conciliation or an arbitration might pale into insignificance compared to the benefits to be gained from resources. But on the other hand, I would still make the point that it is a very expensive process. And I'm not quite sure I agree that the lawyers get paid more than the arbitrators or conciliators. If I can just, there was one matter mentioned, I think earlier, about why countries are going to the International Tribunal for the Law of the Sea and creating a panel under the International Law of the Sea, as opposed to going to the ICJ and having a smaller number of judges hear a case there. And I wonder whether the reason is that ITLOS might be more inclined to accept the judges for that smaller panel that are suggested by the parties. I seem to recall that the agreement that referred the matter to ITLOS actually named the 7 judges that they wanted to hear the case, and I think that might have been acceded to. Judith might know more on that than I do.
Well, we've had a wonderful discussion this evening, a range of perspectives, a range of views, a wealth of experience from everyone. I'll just hand it back to Camille for final remarks.
Thanks so much, Don, and I can only add my thanks to yours for our speakers this evening. A wonderful array of rich observations and insights on a range of topics within the context of dispute settlement. It's been a real treat to hear from all of you who've been involved in these institutions and issues in such a hands-on way. And I'm going to use a fantastic phrase that Judith came up with in relation to the challenges of referring accurately to the PCA. Your comments and particularly your answers to questions gave us both concision and precision. Now, this was our final webinar in the series, so I also need to thank a number of people, everyone who's participated throughout the year, both our speakers who've made this an interesting journey and our participants who I hope have enjoyed the discussions as much as Don and I have. I'd really like to thank Don for instigating the series and being a wonderful co-chair and host throughout the year. And on behalf of Don and myself, I need to extend our thanks to Ansel and to Sipple at the ANU College of Law for their support of the series. And in particular, the wonderful Charlene van der Valk at the College of Law, who's made all the arrangements needed to make these events happen, from registration to Zoom links and recording and sorting out our technical issues. In that respect, if you've missed any of the previous webinars, or if they were so good you just want to watch them again or share them with your colleagues, the videos are all available on the series website, and this one will join them soon. And I know from my own perspective, I'm really keen to share some of the discussions from this series with our students at UNCLOS. So with that, I will thank you all once again for joining us. I hope you enjoyed the discussion as much as I did. Good night or good morning, and have a good evening or a great day.